Let me introduce the rest of today's speakers. Our first speaker will be Lynn Kuok. Lynn is the Shangri-La Dialogue Senior Fellow for Asia Pacific Security in the Singapore office of the London-based International Institute for Strategic Studies. The Institute, or IISS as it is commonly called, is a leading think tank on geopolitical and security affairs. The IISS is non-aligned and draws its members from more than 100 nations, including most of the nations in the Asia-Pacific region. Lynn is responsible for the Institute's research on key Asia-Pacific security issues, and she is co-editor of the Asia-Pacific Regional Security Assessment, which is one of the Institute's signature publications. She's a visiting professor at Georgetown University's School of Foreign Service and a senior research fellow at the University of Cambridge. Lynn will discuss some of the many geopolitical issues and tensions that the Asia-Pacific region is facing today. Lynn will be followed by Nish Shetty. Nish is a partner and head of litigation and dispute resolution at the global law firm of Clifford Chance, based in the firm's Singapore office. Nish is also chair of the Singapore International Arbitration Center's Users Council Regional Committee for Singapore. Nish is co-chair of Council Arbitration of the Mumbai Center for International Arbitration and a judge of appeal of the FIA International Court of Appeal in Paris, which, for those of you who may not be motor racing fans, is the final appeal tribunal for international motor sport. He's a prime finance expert. Nish will discuss some of the many contractual issues raised by the pandemic. And Nish will be followed by Jiang. Jane is a partner in the global law firm of Allen and Overy, based in the firm's Shanghai office. She's a member of A&O's China Litigation and Dispute Resolution practice. Jane has extensive experience across international arbitration, litigation, debt restructurings, and disputes concerning financial products and regulatory investigations. Jane is a prime finance expert as well, and she will discuss some of the issues raised by China's recent opening to the international financial markets and issues relating to cross-border disputes and enforcement. After our speakers make their opening remarks, we expect to have ample time for Q&A. And I would ask those of you in attendance if you would please add your questions to the chat box as we go. Now let's turn to Lynn Kuok. Lynn, the floor is yours.
Thank you so much, Rick, for that introduction, and thanks for the invitation to speak and join this panel today. It's a delight to be here. A warm welcome to everyone joining us. I've been asked to speak about the geostrategic landscape in the region, and so I'll do this by examining four issues. First, I'll look at US-China relations, the rivalry between the United States and China and its causes. This is important because this determines the longevity of the rivalry between the United States and China. Second, I'll look at the Biden administration's likely approach to foreign policy and to Asia in particular. Third, I'll examine the implications of intensifying great power rivalry for the region. And finally, I'll touch on the factors that might militate against competition leading to open conflict. And because my position is that I think competition is here to stay for the medium to longer term, this might perhaps be the most crucial of all the factors that I'll be examining today. So let me first start off by examining US-China great power rivalry. Now, the deterioration in US-China relations has been largely blamed on President Trump. And certainly his attempts to seize upon the trade issue to boost his re-election chances, as well as his trade war, have not helped the situation. But in a sense, the heart of current tensions is not any one issue per se these days. So it's not about the South China Sea or even trade and economic concerns. It's not even about technology and developments in Hong Kong, Taiwan, human rights disputes. These all matter, but at its root now at the root of US-China competition now are deep structural factors. And by this, I mean China's rise and what it means for US dominance in the region. I think seen from this perspective, it becomes clear that the issues that I just highlighted, while they have posed thorns in the side of US-China relations, they have now become less issues to become resolved, but means by which the US-China rivalry may be advanced. So means by which one side seeks to gain advantage over the other. We see that very clearly in the trade dispute, how the United States has sought to gain advantage over China in trade because of its concerns over national security and China's supposed intentions to supplant the United States in Asia. And we've seen that very recently in July, when Secretary Pompeo actually made strong statements supporting the 2016 tribunal ruling in the Philippines case against China. Some 4 years after the award, I think it becomes quite clear then that it's the US-China rivalry that motivated that statement, even though Southeast Asian countries clearly stand to benefit from a strong statement endorsing international law and the tribunal ruling. So given that tensions are intractable, I think given that tensions are structural, I think we're likely to see tensions last beyond the Trump administration. And we often examine the longevity of tensions by looking at the US angle. So will it last beyond this particular administration? But I think what we also need to look at is the Chinese side. And so on the Chinese side, regardless of what happens in the Biden administration, or even beyond that, I think the implications or the effects of the United States throwing basically everything in the kitchen sink at China in the recent year or two will be to harden a belief in China that the United States is really out to clip China's wings. This belief would have hardened under the Trump administration, but really has been shaped by earlier events. So we had the 1995 to 1996 Taiwan Strait crisis, which really made made China sit up and take notice. The 1999 bombing of the Chinese embassy in Belgrade, the 2001 statement by President George W. Bush that China was a strategic competitor. Secretary Hillary Clinton's statement at an ASEAN meeting that the United States had interest in freedom of navigation, an open maritime commons, and the peaceful resolution of disputes. That also greatly concerned China. So I think regardless of how US perceptions might shift in the next or even future US administrations, I think China will be determined to secure its periphery by being the dominant power in Asia. So we can count on US-China tensions to persist. So now let's look at what I think might be a Biden approach to competition as well as foreign policy. So I think what we are likely to see is less inflammatory rhetoric coming from a Biden administration. So that might help to stem or stabilize relations a little bit. But it's also possible that we might see an increase in tensions between the United States and China under a Biden administration. And this is slightly unexpected or counterintuitive because I think how we might see an increase in tensions is that the Biden administration might seek to emphasize human rights more greatly. And this will have knock-on effects in terms of relations with China, but also in terms of its ability to forge partnerships with perhaps countries in the region that are backsliding democracies or authoritarian states. And we might also see a more ideological approach under a Biden administration persist. It started with this Trump administration, especially within the last half a year. We've seen very strong ideological statements from Trump senior officials. So, for instance, Secretary Pompeo made a speech at the Nixon Library, which I urge everyone to read, where he called all communists liars. And I think that's dangerous, I think, because it unnecessarily hardens tensions between between two powers, and it's already a very difficult relationship. So how would we see the Biden administration approach the issue? I think it's quite clear that he will work together with allies and partners. I think the EU is already thrilled by the prospect of a Biden administration, and it's knocking on the US doors to maintain and renew the EU-US partnership. The Financial Times reported a couple of days ago that the EU is seeking to join hands with the United States to assert its interests against authoritarian powers and closed economies. And I think this might on its face sound like a good thing, but as I mentioned earlier, it might have implications for the US ability to forge partnerships with countries in the region and the general stability in the region. Second, we're going to see a Biden administration focus strongly on domestic issues, so addressing the pandemic, which has greatly hurt its credibility abroad, as well as economic recovery by the creation of jobs. In a March piece for Foreign Affairs, the candidate for president from the Democratic candidate, President-elect Biden, insisted that he would pursue a foreign policy for the middle classes. Now, the focus on domestic policy is necessary, but I wonder about the wisdom of seeking first to focus on domestic policy and kind of pushing back foreign policy in the hope that somehow by strengthening the country from within, that its approach to the outside world will also resolve itself. I think it's useful to remember what the founding father of Singapore, Lee Kuan Yew, said about the region, namely that Asia is not a movie that you can kind of press pause and return to at a later stage and hope that nothing has changed. Because if the United States presses pause while it's looking inwards at development in Asia, it might come back to a region that's dramatically changed, dramatically and irreversibly changed. And in terms of a foreign policy for the middle classes, I think the way it is conceived might pose obstacles for things that would be strategically beneficial for the United States, like rejoining the TPP. I think this would put a failure to promptly join the TPP would be denying the United States of a means by which it could usefully signal to the region that its engagement with the region goes beyond just military engagement, but is also deeply rooted in economic ties and its desire to see the region both stable and prosperous. And finally, I think we often talk about the Biden approach to Asia, but we ask less what the Biden goals towards Asia might be, or even the US goals towards Asia. What, at the end of the day, is the United States seeking to achieve in Asia? And I think this question is very important to ask because it also determines how intense US-China competition is going to be. So two possibilities here, two main possibilities here. The first one, simply to ensure that in US-China competition, China plays by the rules. So that's one level. It might also go beyond that. The United States might be concerned to ensure that it remains the region's hegemon. And I think the latter outcome might be a little bit less palatable for countries in the region because all countries are quite willing to join hands with the United States if it says, I'm concerned about, ensuring a rules-based order so that all countries, big and small, can be stable and prosper. But I think beyond that, I think countries would be very hesitant to join hands with the United States and its allies if if US goals are framed as seeking to ensure that the United States remains dominant in the region. And then finally, what are the implications for US-China rivalry in the region? I think what's clear is that, hotspots in the region, so the South China Sea, the East China Sea, Taiwan, the Korean Peninsula, all these hotspots are going to become even hotter. So that's probably not something ideal. But given that, how do we ensure that intensifying competition in the region does not go overboard? Are there guardrails for ensuring that tensions are kept in check or competition is kept in check? I think what we are to hope for, and I think what the Biden administration has indicated, is that his administration will look for areas of mutual interest that the United States and China can cooperate on. So the most obvious examples of this would be the pandemic, as well as climate change. And I think these are areas that the two great powers can usefully cooperate on, because a failure to ensure resolution of the pandemic or stem climate change would hurt both countries. Cooperating to resolve issues like trade and technology fights, I think that would be a little bit harder, given how some of these issues have taken on added meaning as I mentioned earlier, a means by which one side gains advantage over the other. So first, countries should look at how whether they about identifying areas where they could cooperate, and in the absence of these areas where they can cooperate, I think what is critical to ensuring that relations don't boil and result in open conflict is that we must ensure the promotion of the rule of law and that competition takes place within multilateral institutions. Second, there needs to be firm adherence to agreements agreed upon by the two countries to minimize the risk of open conflict. And in this respect, I'm referencing the 2014 Memorandum of Understanding between the United States and China for safety of behavior at air and sea. And I think this is critical to ensure that, say, any incidents in the South China Sea don't go overboard. And finally, I think it's very important that we shift away from the very unhelpful ideological slant of the dispute, because that unnecessarily deepens divisions between the United States and China. It limits partnership options in the region. So, for instance, countries like Vietnam are critical to general stability in the region. Likewise for smaller countries like Malaysia, etc. But I think finally, the reason why we should think about moving away from the ideological approach is that it might be counterproductive in leaving a strategic space open for authoritarian states to then advance its interests and also result in democratic backsliding, which I think would be very bad for the region's stability as a whole. So I'll stop there and I'll be happy to answer any questions. Thank you.
Well, Lynn, thank you very much for the very insightful remarks. I hope we have the ability to come back to some of the points that you've touched upon in the Q&A. At this point, we turn to Nish Shetty. Nish, the floor is yours.
Thank you, Rick. Thank you for giving me this opportunity to address everyone. So it's good morning, good afternoon, and good evening, depending on where all of you are. Look, I'm sure this pandemic has affected each and every one of us in some way or the other, right? Whether it's interaction with others, how we socialize, how we work, where we live, our outlook on what the future holds. I mean, we could spend the entire day discussing all of these and we would just be scratching the surface. Thankfully, in the 10 minutes or so that I've been given, I've been asked to focus on something far more limited. So effectively, what I'm going to focus on are two things. One, contracts, in particular, sanctity of contracts and how the pandemic has affected that. And secondly, financial markets. Now, I'm a mere lawyer, so I'm going to focus on the financial markets and the impact on those markets through the lens of a lawyer. So, and I'll come back to that in a minute. I think from a impact perspective, I'm going to look at three aspects. First, how parties to contracts reacted when the pandemic first unfolded, how governments then reacted, and then finally how the financial markets reacted. How did parties first react when the pandemic first unfolded? I guess the first question there is, when did the pandemic first unfold? It depends to some extent on whom you speak to. For many of us in places like China, in Hong Kong, in Singapore, we would say it unfolded in January and February of this year. For a lot of the rest of the world, it sort of unfolded between March and April of this year and thereafter. Till then, for many, quite wrongly, it appeared as an Asian problem, and I can't help but think that was a throwback to the SARS experience and so on. But a lot of people looked at it as an Asian problem. Since then, it's become readily apparent that it's far, far, far more than an Asian problem. It's a global problem. So what happened contractually from a legal perspective when this unfolded? I think the first visible contractual reaction was the phase that I'd call the force majeure / frustration phase. In early February, newspapers reported that CNOOC, the Chinese national oil company, declared force majeure in relation to its long-term LNG contracts. It was also reported that Beijing had issued what it called force majeure certificates to companies that it felt were unable to fulfill contractual obligations due to COVID. Now, leaving aside how effective those certificates were, etc., that was the first sort of visible, globally reported reaction on a contractual level to the pandemic. And then it wasn't limited to China. Many contractual counterparties went down a similar path of declaring force majeure and frustration, and thereby seeking to avoid the consequences of their contractual obligations. Given in many instances, quite rightly, the impact that the pandemic had on their businesses. The argument, as many of you will know, is basically that they are unable to perform their contractual obligations due to an event beyond their control and beyond parties' contemplation. That, in a nutshell, sort of encapsulates the force majeure principle. Now, in the time that I have, I won't go into the niceties of the law of force majeure, but it suffices to say that a successful application of those principles requires a careful review of the clauses themselves, and assuming such clauses exist, and whether it's wide enough to cover an unprecedented and, in many respects, an unexpected event like what we've seen through COVID-19. So, in a nutshell, that encapsulates the immediate reaction, the immediate contractual reaction. No doubt, over the course of the next couple of years, and a lot of these are coursing through the courts and arbitral tribunals as well, there will be resolution of these disputes, these invocations of principles like force majeure and frustration. Since then, there have been other attempts to achieve thematically the same consequence, which is, on the one hand, an attempt by those that feel that our contractual obligations have not been fulfilled to have those obligations fulfilled, and those that are subject to those obligations saying that they're unable to fulfill them for one reason or another. So that's the first sort of impact, contractual impact on a global scale. Now, let's move then to government reactions. I think it's fair to say that at the governmental level, the reaction to the pandemic itself has not been uniform. From citywide and countrywide lockdowns and curfews in some countries, for example, China, to more modest steps in some parts of Europe, to no discernible steps in places like Sweden, quite deliberately, to public declarations of this being over by Easter in some other parts of the world. Now, those reactions have also produced different results. Large countries like China seem to have gotten the pandemic under control, although there are sort of periodic spikes as well. And there are other countries where new records are being set daily for new cases. Again, from a legal perspective, from a contractual perspective, what we've seen as a fairly common reaction in many parts of the world is relief from strict contractual consequences of a failure to perform obligations. So let me talk a little bit about that. So the governments in many parts of the world looked at the pandemic, looked at the impact on businesses, and said, this is an event that is so unprecedented, if we allow individuals and companies to rely on their strict legal rights, then you're going to create a greater catastrophe. There will be distraction in terms of economic activity and so on. So what many governments felt was the need for broader relief as a matter of public policy, given the unprecedented nature of the pandemic itself. One common form of that relief is insolvency relief. In many countries, moratoria on insolvency-based actions against debtors was introduced. So one example would be if a statutory demand required 21 days to fructify before one could rely on that statutory demand to start an insolvency action. That time frame has been extended. For example, in Singapore, it's been extended to 6 months or more, and in some other countries. So thereby effectively preventing someone who would be a creditor from seeking the liquidation or bankruptcy of a company or an individual. Rental relief, inability to repossess properties on account of a failure to pay rent is another example. In Singapore, the government, in addition to introducing a lockdown, which it sort of dubbed a circuit breaker, a very effective circuit breaker, incidentally, it also introduced temporary legislation to address sort of 5 broad categories of contracts: certain loan facilities, construction-related contracts, in particular performance bonds, which are typically enforceable without notice as such, leases and licenses of non-residential properties, i.e. commercial properties, event and tourism-related contracts, and certain types of hire purchase and conditional sales agreements. Again, thematically, all of this was intended to prevent a shock to the economic system. Or even if it's not to prevent a shock, to mitigate the shock that was already being felt by the economic system by virtue of the pandemic itself. Yes, as a purist lawyer, you will say that this is interference with your strict contractual obligations, but the view that was taken, and I think quite rightly so, was that there were greater considerations at play. Now, in terms of impact, while that may have prevented a sort of run towards insolvency, what a lot of people are predicting is a legal pandemic. And what that means, I think, is that although these counterparties have been prevented from taking immediate steps, enforcement steps towards insolvency, the rights themselves have not extinguished. So, for example, you may not be required to pay up, but your obligation hasn't gone away. And in many instances, if default interest, for example, is applicable, that would continue to accrue. There is criticism of that, because what that will then mean is you're left potentially with a larger debt to repay when things get back on the ground, start moving, and the protection given by these temporary measures is lifted. It remains to be seen how all of this will play out, but at least for the moment, it's given the economy in many parts of the world and businesses breathing space to try and get back on their feet. Right? How has this been received by the industry? I mean, how have these measures, how have these attempts to try and sort of change strict contractual rights and obligations been reacted to? I guess it depends on whom you speak to. The person getting the protection is obviously happy with it. Those that are affected by it and who can't enforce have quite often a different reaction. And on the back of that different reaction is a reality that says that those individuals, those businesses may in turn be obligated to others. So, for example, if rental isn't received, then that individual or that organization may well be obligated under a finance agreement to repay a bank, for example. So how is that treated? So I think most governments have recognized that these aren't perfect solutions, but steps that they've had to take in order to deal with an unprecedented circumstance. Finally, in terms of financial markets, and I said I'll come to this at the end from the perspective of a lawyer. I guess I can't help but observe that the Dow is at or around 30,000. The S&P is approaching 3,700. So I guess even a basic investor like me would say, "What pandemic?" Right? Looking at those sorts of numbers. It looks like in March all we had was an irrational blip, and things were back to normal. And what I would call the stimulus fueled party is still raging on insofar as the financial markets are concerned. Where others who are far better qualified to answer this question would have to I guess form a view is whether the real economy reflects the optimism that one sees in the financial markets. And given the reach of P.R.I.M.E, both in terms of the audience and in terms of the panelists, no doubt that will get answered in some shape or form in the course of the events to follow. So let me stop there, and we'll be happy to address questions during the Q&A. Rick, back to you.
Thank you very much, Nish, and we'll see if anybody picks up on the question that you've raised there at the end. In the meanwhile, let's turn now to Jiang. Jane, the floor is yours.
Thank you, Rick, and good morning and good evening to everyone. And Rick, you asked me to talk about China. It's a very big topic. As Nish said, I will put on my disclaimer. I'm a mere lawyer, so I can only see the development of China through the lens of law. So I think really my sense is in the time of uncertainty and the increasing geopolitical tension, as mentioned by Lynn, two topics are typically very close to the hearts of everyone. One is enforcement risk, the other is litigation risk. I will briefly address both in terms of the developments in China. On regulatory enforcement, my experience is mostly relating to financial industry, which is very relevant to this forum and audience, I think. I think if you ask yourself, will the regulator come after me? What are they going to come after me for? Then I think we first need to set the scene a little bit, because discussion of regulatory enforcement risk, especially in the financial markets, become particularly relevant at this point of time. You probably all are aware that as a result of the dialogue between China and the US, there is a significant opening of the financial markets recently. I will highlight three developments. One is for those who invest in the China securities market, the QFII regime has been significantly improved. So you will see the removal of quota and the removal of some eligibility requirements for those who wanted to be qualified as a foreign investor to utilize QFII. And the scope of product investment has significantly been expanded. So I think the message is clear from the Chinese regulator. Please, you're welcome to invest in Chinese securities market. And I'm not surprised at all. I mean, there are, of course, deeper economical incentive behind that, but also is because QFII channels are much better or more regulated than any other channels, for example, like the Stock Connect, the Bond Connect. So there is a heightened transparency to the regulators so they can better regulate the investment activity. So we should always bear this in mind. The second development is that many foreign investors now can hold and controlling or the entire stake in certain types of financial institutions, such as wealth management companies, life insurers, securities companies, futures companies, and fund management companies. It is very exciting for them now. They can take control of the financial institution they have in China. But at the same time, it is the first time for them to be fully in charge of the legal and compliance risks in China as well. So it's not surprising that many of them are concerned. The third development is relatively minor, but I think it's important in terms of the financial markets infrastructure. That is, foreign invested rating agencies can now rate all types of domestic bonds. I think that is also an interesting development to watch out for. So all these developments pointing towards more participation by the foreign investors in the Chinese financial markets. So what should they watch for in terms of enforcement risks? I think if you look at the past 5 years of enforcement records, two particular issues stand out. One is on information disclosure rules. Well, I'm not only talking about in IPO scenario, but also routine shareholding disclosure. For the second area, this is particularly relevant to QFIs because of their portfolio investment, and some of them have a group investment structure, and how to calculate their shareholding aggregation is a complex task. If you look at the statistics in the past 5-6 years, this type of violation has occupied 30%, sometimes more, of all the enforcement cases on the securities market. So it's clearly a focus of the regulators. And then the second area is really the failure to perform due diligence by intermediaries. The newly amended securities law has increased the penalty for this type of failure from 5 times the business income to 10 times the business income. It's clearly signaling a stronger supervision and enforcement step up. If you look at the number of cases, back in 2017, there are only 26 cases for this type of enforcement. And now we have 108 cases this year up till October. I think in this area, it is very relevant to the securities companies that may act as underwriters and accounting firms, and in my mind, potentially rating agencies, especially in a bond default situation. So I think these are the enforcement risks. I mean, just to add a personal commentary, I think really it has been very interesting for me to observe over the years the development of regulatory enforcement process in China. In a way, the participation of foreign investor in this process has propelled along a number of significant development in this area. I mean, of course, I don't want you guys to get into trouble to help to improve the Chinese regulatory enforcement process, but the objective result is that you have helped them. For example, I think 2015 is the first time after the stock market crash that foreign investors get into trouble with the Chinese securities regulators. And when we participated in those process, you will see things like calling foreign expert, hearing with a translation facility, administrative settlement with foreign parties. They are all brand new to the Chinese securities regulators. But they, in a way, quite admirably has risen to the challenges and adopted many of those procedural components suggested by the foreign investors. So hopefully, I think increased participation of foreign investors brought by this round of opening will continue to put to test the Chinese regulators' ability to manage and supervise this financial market. So I think that's probably the first part. Let me move on to the second part. That is the litigation risk and cross-border enforcement. I think it's probably easier if you think of an example. You have a shareholders agreement with a Chinese partner that is governed by foreign law and subject to a foreign jurisdiction. I think the question you have would be, if you get a favorable judgment in that foreign court, will you be able to enforce that judgment in China, in a Chinese court, against the assets of your Chinese partner? We've seen a lot of those cases unfolding. Basically, under Chinese law, you have 2 grounds to enforce a foreign judgment. One is based on international convention or bilateral treaty. honestly, I don't think there is much to be said because China has signed the Hague Convention but has not ratified it. And that is not operational for China and for most of countries. And China has signed a number of bilateral treaties, but they are limited. And also, notably, the UK and the US are not included. So I think in terms of looking at the practice of reciprocity, the second ground on which you could enforce a foreign judgment is far more interesting. Historically, I think a lot of you have been told that China wouldn't recognize foreign judgment on that basis. And indeed, the history told us that Chinese courts have rejected many foreign judgment, including, if I recall correctly, Japan, Germany, England, Australia. So that's a long line of denial of enforcement. But recently, the scene started to change. In 2015, a Wuhan Intermediate Court has recognized a judgment by a Californian court for a shareholders dispute. The basis of that is that a Californian court has enforced a judgment issued by the Hubei Province High Court. For those who are not familiar with the Chinese geography, I'm not very good with this either, but just to explain that Wuhan is a city situated in Hubei Province. And the second case is the Nanjing case. The Nanjing Intermediate Court recognized a judgment issued by Singaporean court for product sales dispute on the basis that Singaporean courts have recognized and enforced the judgment from a Suzhou Intermediate Court. Again, Suzhou and Nanjing, they belong to the same province, Jiangsu province. So, and these cases, together with a couple of others, seem to sort of demonstrate there is a common ground on reciprocity. That is, it is not operating state by state, but rather province by province, which is, I'm not sure that's the right way of looking at a reciprocity. Usually is a state by state relationship. And indeed, the matter becomes more complicated if you are dealing with a foreign country like the United States. You have a federal system that each state is distinct in terms of its legal system. And so on the one hand, you look at which province in China has been recognized, and on the other hand, you look at which court in which state of the United States they have recognized the Chinese decisions. That considerably narrows down the basis of reciprocity. Fortunately, in 2018, there is a case by Shanghai number one intermediate court that it is held in that decision that we will recognize a U.S. judgment just simply based on state by state basis, nation by nation basis. We're not going to qualm about whether this court has recognized a judgment by Shanghai courts. And so that's very welcome development. But looking at the long train of cases, I would think that's up till now an outlier. So the question is, how would it change? Would it head towards more relaxation? I think in a 2015 Supreme Court opinion regarding One Belt, One Road country, it is even envisaged that China in some cases would proactively create reciprocity by recognizing a judgment from a country first before they enforce a Chinese judgment. That is already the kind of legal basis is already there, but it hasn't been done yet. And also then coupled with the geopolitical tension, as Lynn has introduced us to, the question is, will this develop? I mean, if you look at law as part of the ideology makeup of China, then would we open up mutual enforcement under this in this environment? I don't think I can really predict. All I have to say is it's remain to be seen. I would hate to see that they would differentiate between countries in terms of reciprocity. That would be definitely against the rule of law. If you are like me, hate to rely on uncertainty, and you would like some advice of action rather than advice of waiting, then I think I would recommend now you look at Hong Kong arbitration. I think that's also an area that has seen quite a lot of action, not only because there is mutual enforcement of arbitral awards between mainland authorities and Hong Kong authorities, which is the sort of rough equivalent of the New York Convention, but also in 2019, the authorities from both sides have taken a significant step to support mutual recognition of interim measures supporting arbitral process. That means before you even start the arbitration, and of course during the arbitration, you could freeze the assets or protect the evidence in mainland China to assist a arbitral process in Hong Kong. That, in my mind, has significantly increased the success of enforcement of the final award. Relying on the statistics of HKIAC, which is one of the 6 qualified arbitral institutions under the regime, we have seen 13 applications in 2019 to 10 different Chinese courts. Those applications have been successful and resulted in the preservation of, in aggregate, I think, $800 million assets. That's not insignificant. And if you look at this year, the statistics increased to 23 applications. So I think if you are in any doubt that whether this mechanism is well oiled and well tested, I would say it is yes. At least you are not first to the party. So I think I'm coming to the time that that is allocated to me. Well, as you can see, many interesting developments here in China in terms of enforcement and the litigation risk. They always evolve with the changing international landscape, and we are forced to adapt. I think now is time to hand you back to Rick, maybe.
Well, thank you very much, Jane. I hope we can come back to the points that you've raised in the Q&A. We do have some questions coming in, and the first question is going to go to Lynn Kuok, and it comes from Andrew Pullen at Fountain Court Chambers in Singapore. And Andrew asks, it appears that the tensions in the regions will not be confined to China and the U.S. What do you make of the rising tensions between China and Australia? How is that likely to play out? Do you expect similar scenarios between China and other countries in the region? So, the question that I would ask is, to what extent might local conflicts between local powers become conflicts that we need to be concerned about in the financial markets? Might any of those become a kinetic conflict, result in actual armed conflict that would be disruptive to the financial markets? And Andy ends his question by saying, will that drive will these tensions between China and other countries in the region drive APAC countries into the arms of the U.S.?
Thanks so much for that question, Andrew. I think we can probably group groups of countries in terms of the likely approach towards China and the United States. So, for instance, if we look at Australia, that's a country that's part of the quadrilateral security dialogue with the United States. So, Australia, India, Japan, the United States, they're all part of the Quad countries, which in its original conception was meant to be a more muscular approach towards regional security. So Australia tends to be has recently adopted its strategic update, and I think that was a very significant document, because what it did was it clearly identified challenges to security in the region and its need to focus more on its near neighborhood, and also committing resources to being able to tackle some of these challenges. I think it broached the question of China quite delicately, but I think it was clear what its concerns were. But even with Australia, with very thorny relations right now, I think we are likely to see Australia try to avoid for want of a better word, demonization of China that at least towards the tail end of the Trump administration, we have seen. I think what it's going to seek to do, so that it also balances out its economic interests, is to say that what we're actually looking for is, promotion of a rules-based international order and ensuring. So, for instance, in its push for an investigation on the origins of the coronavirus, I think what it was saying is that this is necessary in the international community's interests. We need to find out how this develops so that we can address it now and in the future. So it's made what China's recent actions, turning the screw in Australia, is probably making this approach harder for Australia to adopt. But I think as far as possible, it's going to avoid it being a dispute between Australia and China directly, but one that seeks to ensure better behavior. And then we have India, of course, also perhaps more forward-leaning than some of the other countries. India has invited Australia for the first time for Malabar exercises, joint military exercises with the United States and Japan. But I think India as well would be cautious to just jump on board with whatever the United States says in terms of, approach towards China. Also, India faces its own domestic concerns. It's facing a huge coronavirus challenge, issues with Pakistan, etc. So, and also it's got a habit or a tradition of non-alignment. So I think India would also be quite reluctant to go headlong in conflict against China, especially in the context of US-China rivalry. If we look at the smaller countries in the region, so Southeast Asia, for instance, certainly tensions in the South China Sea are rising because of the increased presence of Chinese vessels and the increased frequency of close encounters. So that can very easily spark off conflict. So I think was earlier this year as well as last year, we saw Chinese vessels collide or deliberately collide into the vessels of the fishing vessels of the Philippines as well as Vietnam. And of course, this can very easily escalate and get out of hand. But I think for the smaller countries, they would be even more wary of going headlong against China. They know they're greatly outmatched, but also they look at some of the tensions in the context of the broader bilateral ties and the need to maintain relations with a very powerful neighbor. And not only a powerful neighbor, but a wealthy neighbor on which some of these countries' own prosperity depends. So, even though they have strong and fundamental disagreements in the South China Sea, we've seen trade and other economic ties between China and the rest of the region increase. And I think that has so far prevented a more front-long collision with China. So that said, to answer your question on whether they'll drive countries into the arms of the United States, I think what's quite clear in terms of how Southeast Asia approaches it is that they want to be friends with both China and the United States. And even though China might be turning the screw a little bit on them, I think that overall policy stance they will seek to maintain. And so they've persistently said that they do not want to choose between China and the United States. So I would say, provided things don't get far worse, we are likely to see them continue their overall stance of seeking to balance between the two great powers.
So perhaps not the rising tide, going back to Governor Orr's remarks, rising tide of China-U.S. competition, but not a wildfire or a storm that's likely to provoke a conflict. If I can just draw my conclusion from your remarks, that's not to say that it couldn't happen. In the time that remains, let's get a quick question for Nish and a quick question for Jane. Nish, for you, you spoke very interestingly about extra contractual ways of resolving what could have been disputes, moratoria and the like. With that having been said, has there been, coming out of the market volatility in the first quarter, early second quarter of this year, have we seen some disputes that have gone to litigation or arbitration, despite these extra contractual mechanisms. And looking forward, do you think this is likely, if we have another similar crisis, that we will see more potential disputes resolved in this extra contractual way rather than through traditional means of resolving disputes? That is to say, litigation or arbitration.
Sure. And I think the short answer is yes. We have seen disputes, notwithstanding these extra contractual measures. I mean, these extra contractual measures, by and large, have been limited to certain types of contracts in many jurisdictions. That's the first point. So it's not every contract. Secondly, a lot of the focus has been in terms of insolvency type enforcement action. Now, long before you get to an application for an insolvency-based relief, you still need to establish your entitlement to either damages or some other amount of payment. Now, insofar as those things are concerned, particularly in the arbitration field, that's been continuing. What did happen was both the courts and the arbitral tribunals, when the pandemic first hit, pressed pause on hearings. So there was a question mark around how hearings could continue, given the social distancing requirements and so on and so forth. So that was a relatively limited period. Since then, both the courts in many jurisdictions and arbitral tribunals have moved forward in terms of proceeding with the disputes through virtual means. And it's become quite the norm these days to have hearings conducted via Zoom or other similar sort of platforms. So disputes are continuing. Are they going to increase? I think history tells us that whenever there is a shock to the system, that shock reflects in parties seeking to enforce contractual rights because of the economic impact of those shocks. And I think this is going to be the case now as well and moving forward. What you also see is a little bit of a gap between the event itself, the event that creates the shock, and the disputes coming out. So my guess is that we're in that period. You can use many analogies. It's water receding before a tsunami, whatever you want to call it. But really, I do think that that's going to happen. And I'll end off by referencing something that Deloitte's published quite recently, which I found quite interesting. About it was a comparative analysis of various banks and their sort of non-performing loans. And that comparative analysis showed a huge uptick across both regional and global banks in terms of that non-performing loan portfolio. Obviously, not every single one of those will end up in a dispute of some sort in either litigation or arbitration, but I think a fair few of them will end up having to be resolved through the traditional dispute resolution mechanisms. So I think we will end up back in the traditional arena of litigation, arbitration, and the like. And these temporary measures that various governments have introduced will be just that. They will be temporary while we're all getting through this particular crisis.
Okay, well, thank you. Jane, one final question for you. You spoke about the opening of China to global financial institutions and the opening of the Chinese markets. To what extent, and this ties in very nicely with the interesting how it ties into some of the geopolitical competition issues that Lynn was raising, and the decoupling, or potential continued decoupling between the United States and others, perhaps, and China. Yet this seems to run counter to that decoupling. In fact, it's just the opposite, and it's certainly in the interest of global financial institutions, including the big U.S. financial institutions, in further involvement in the Chinese market rather than decoupling. To what extent do you believe that this is China's motivation is to potentially co-opt U.S. financial institutions into supporting or opposing decoupling? And to what extent is it motivated by China's interest in developing its capital markets, or is it some combination of the two?
Thank you, Rick. It's a very good question. Actually, originally, my part of the talk, I started with the geopolitical tension. You always have losers and winners, and I think actually the financial industry, the financial sector in China, in terms of all these turbulent times, is almost a winner of this geopolitical tension, because market access has always been one of the bargaining chips between the two countries. So this time, this bargaining chip is given out in exchange for something else. So, and when this chip landed on the table, I think there are a number of thinking behind this. This is what I believe, that China wanted to upgrade its service industry. So that is aligned with that objective, basically upgrading its industry makeup. And then secondly, if you look at it, it's either the opening is either in the investment of securities market, which increase the liquidity of the securities market, and more sort of long-term investors in comparison to the disparate kind of individual speculative investment in the stock market that would actually bring stability into the stock market. And then thirdly, I think the industries opened for foreign investment. There really, a lot of them are in the asset management industry. I think it's a kind of a win-win situation where the Chinese regulators see quite clearly that the asset management industry needs improvement and need a push up by the foreign competitors. And at the same time, it does have huge attraction on the foreign investors because of the mass affluent population and the market potential of asset management for the entire population. So I think it is in one of those turbulent times. This is one bright spot that I believe will continue to develop and develop positively. So in my mind, the only question is when it comes to enforcement, then we will see the true test comes whether there is any selective enforcement, there is any enforcement motivated by geopolitical tension, and whether the enforcement could be handled even-handedly and with procedural justice.
Well, thank you very much, Jane, for ending on what is at least a somewhat hopeful note, although certainly caveated as you did. I'm sorry that we don't have time for more questions at this point, but we've already gone past the top of the hour. That's our allotted time. Before I thank our panelists, please allow me to cover just a few additional points. As I mentioned at the beginning, today's event was the first in our session in our Asia Pacific conference. We have two additional sessions coming up. Evolving Business Challenges on Tuesday, the 8th of December at 7 p.m. Hong Kong, Singapore, Shanghai, 8 p.m. Tokyo, 10 p.m. Sydney time, and then a third session which will cover some of the points that Nish Shetty was alluding to towards the end of his remarks about how arbitral and arbitral panels and courts have dealt with the pandemic, and that is how disrupted dispute resolution. And that'll be on Thursday, the 10th of December at 10 a.m. Hong Kong, Singapore, Shanghai time. That's 11 a.m. Tokyo, 1 p.m. Sydney, 9 p.m. in New York on Wednesday, the 9th of December. Do join us. Sign up links are being shown in the chat box now. I would like to take this opportunity to thank very much our global law firm sponsor, Clifford Chance, as well as DTCC, LCH, and Rutter Associates for sponsoring this conference. In addition, I would like to thank Lexis and MLEX for their support. I'd also like to thank my fellow P.R.I.M.E finance experts who assisted in the organization of this conference. Akihiro Wani from Morrison & Foerster in Tokyo, Chong Lu from Linklaters in Hong Kong, Keith Noyes from Hong Kong, Paul Landless from Clifford Chance in Singapore, Jalita Panjaitan from Linklaters in Singapore, Scott Farrell from King & Wood Mallisons in Sydney, Judge Elizabeth Stong in New York, P.R.I.M.E's chairman Bob Pickle in New York, and P.R.I.M.E's founder Jeffrey Golden in London. And of course, once again, I would like to thank Camilla McPherson, P.R.I.M.E's head of secretariat, who does so much for us, including staying up past 4 a.m. in The Hague to be with us. P.R.I.M.E Finance is a not-for-profit foundation, accepts donations through Friends of P.R.I.M.E to support its work. If you would like to make a donation or to find out more, please contact Camilla using the details shown in the chat box. And if you're interested in sponsoring a future P.R.I.M.E Finance event, please do get in touch. Now, all that remains is for me to thank Governor Adrian Orr, Lynn Kuok, Nish, Shetty, and Jiang for their excellent contributions to this session, and to thank all of you who are watching for your attendance. We hope to see you again for our second session next Tuesday, the 8th of December. And that's all for now. Good day, good night, stay safe, and stay well.